Mr. Boyd?
On board, yes, ma'am.
Okay. Is it
It's a
a,
rejection.
okay. Good morning, sir. Are you David Alexander Boyd?
Yes, ma'am.
And Mr. Boyd, in cause number 25, DCCR 0720, you're charged with a third-degree felony offense of deadly conduct, discharging a firearm from March 20th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I'm going to get a plea bargain rejection. What is the offer?
The state's offering 10 years, probated for 10 years with a $2,500 fine, standard conditions and no contact with a couple of complainants, as well as stay away from the Little Woodrow's establishment.
Sir,
Yes.
spit whatever is in your mouth out in that trash can over there.
Sorry, Governor.
So you've signed a plea bargain rejection with your attorney, Mr. Jeffries, and it's going to show 10 over 10, right?
That's right, Judge.
So it's for, if you wanted to enter a plea of guilty for a 10-year term in prison, that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $2,500 fine to follow all of the rules and conditions of probation. You have every right to reject that and have your case set for trial. I want to make sure you understand today what your options are if you wanted to plead guilty and what your possible consequences are if you go to trial and are found guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. Coleman, is there any reason to believe that that offer would change?
Not at all, Judge.
So, Mr. Boyd, I want to make sure you understand that after today, I don't accept plea agreements once they're rejected. So unless new information comes to light with your attorney or the district attorney's office, then if you change your mind later and want to enter a plea of guilty, it would be to something different than this or open to the court. Do you understand?
Yes, ma'am.
All right, then we'll get your case set for trial and Mr. Jeffries will begin preparation. And if y'all will just send that through, I'll
Just see.
sign off on it. Okay, perfect. You're free to go, sir.
Thank you, ma'am.
Larry Fletcher. Good morning. You're Larry Fletcher?
Yes, ma'am.
And Mr. Fletcher has 3 cases. He has a motion to revoke his probation, and then 2 new cases, cause numbers 25 DCCR 0839, a manslaughter case, and 25 DCCR 0838, an assault, aggravated assault with a deadly weapon. And what is the, so there was we were here at one point, and he entered pleas of not true in the motion to revoke probation. And it was, I guess, kind of reset for sentencing, but with those new cases, what?
Your Honor, with the court's permission, the state would like to proceed on the MTRP first.
Judge Matt, if we're going to do that, I'd ask the court for 2 weeks.
No, we're not doing that today. I mean, because
No, okay, I'm sorry.
no,
I'm
not inclined. So, okay, here's the thing. Typically, the way I'll handle motion to revoke in new cases, if the new cases are, I don't want to have to hear it all twice. So if it's a new case and it's a witness or 2, that's one thing, especially if it's a lesser offense. With these types of offenses, would typically be more inclined to hold the motion while we take care of the other cases.
The state's thinking, Judge, is depending on the outcome of the MTRP, I think that would be dispositive potentially of the other cases without the necessity of having to pick a jury and go through the jury trial. But that's just the state's preference too.
Right.
I understand the court's decision.
No, and I'm not saying I'm opposed to it. I'm trying to, so this underlying offense that he's on probation for is a second-degree felony. So what would it would be proving up the aggravated assault and the criminally negligent homicide?
That's part of it, yes, ma'am.
Time frame on that type of hearing?
Wouldn't be extensive, Judge. No more than a day. No more than a day. That's probably at the high end.
All right, so he's already entered the pleas of not true. So I'm going to kind of grant what Mr. Coleman is requesting on this one.
If it's essentially, and I'm not complaining about it, Mr. Coleman has the right to do whatever he wants here, but if it's essentially going to be miniature trials, then I would ask the court for some time.
Sure. No, so what I'm going to do is reset it for sentencing. Obviously, I need to find a day. Probably going to be 45 to 60 days out. Obviously, I know that might be quick to get ready for a trial, but I think you should already have
We're working through the discovery.
the discovery.
Yes.
Is there anything you're waiting on? Anything that's pending, outstanding?
Yeah, I'm not aware of it, but he's saying no, so then. my
So
answer would be no.
because we're going to do it this way, let's do about 60 days, and then we'll look and find a day on a week where we do not have a trial, and I'll give you guys at least a day on those weeks. We can even have a little bit more. All right? Okay, we'll see you back. Good morning, sir. You're Patrick Gallagher. And Mr. Gallagher was previously in court, entered a plea of guilty to driving while intoxicated, third or more. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Your Honor, yeah.
Are there any additions or corrections?
Nothing was mentioned.
I didn't see any, Your Honor.
So, Mr. Gallagher, you want to know what my big concern is? How long were you off probation for your DWI second when you got your DWI third?
I can't remember.
4 days.
4 days.
That's what it looks like to me. It expired, community supervision expired, looks like October 3rd of 2024 is the way this reads. New case, October 7th of 2024. What, if anything, have you done with regard to any kind of drug treatment? Anything on your own to stop using alcohol or drugs?
I quit drinking and I pray to the good Lord because I'm a single dad with grandkids, so that's over with.
Well, it should have been over with when you were on probation last time.
Yes, ma'am, I agree.
And I appreciate that you're praying, but sometimes that's not enough.
I agree with that too.
Are you still working
Yes, ma'am.
at Exxon?
Yes, ma'am.
Judge, there is one issue I need to bring up whenever you're done speaking.
Go ahead.
I'd spoken to the prosecutor about this. He is a full-time shift worker, and one of the issues was he had brought in his work schedule as if the court was willing to, he had dates that he was not working to do the 10 days.
Okay.
And that is something that being the courts.
Sure.
Oh. You weren't quick enough. You were quick, though. Okay.
It was the highlighted dates is when he is not working, that he was asking the court to. I know, he knows it's a big ask, but.
Well, I mean, I don't know, it kind of is, it kind of isn't. Typically, I let people who are working do it on weekends. This is just how the weekends,
I have no
for his
issue
weekends.
with the erratic nature.
Here's the more, I guess, the part that's going to be potentially something that you're going to have to really figure out with your job schedule, and there's not going to be any excuses, is that you're going to have to enter and successfully complete the JCDI program. It is an intensive outpatient program. You're not the only patient that will have to do it on this type of schedule, but you're going to get started on that immediately without any mess ups, because if so, you're right back in here and you're going to be looking at going to prison. Do you understand? So what I'm going to do then, Mr. Gallagher, is find that you entered your plea of guilty freely and voluntarily. Have you been wearing a drug patch either, or no? Was that a condition of anything? I didn't,
No, no judge. it
the
was.
bond, it wasn't a condition? Well, because there was, the blood came back with positive of Delta 8 THC. I'm sorry?
That's correct.
Yeah. Are you doing anything like that still?
No, ma'am, I work for ExxonMobil.
Well, I mean, did you work for them when you,
I did, but I had a vape that I didn't know was there, so that's history.
you're 52 years old and you're using a vape that you don't know what's in it? Do you want me to buy that?
You don't have to, don't matter.
I don't. Because if you don't know, then you should have known. So either way, it's ridiculous that, I mean, that's something that a teenager would come in and tell me, I got a vape and I don't know what's in it. All right, I'm going to do this. Going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow your agreement. Find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement. Well, actually, I'm not going to follow the agreement with regard to the length of time on probation. The fact that he was just off of probation, I think, warrants longer than a 5-year probation. The length of your probation period is ultimately up to me anyway, so it's not like I'm following the main part of the deal, but you still wouldn't have a right to appeal because that's up to me. So I'm going to find you guilty, sentence you to 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that and place you on probation for 7 years. You're ordered to follow all of the rules and conditions of probation. That's going to include entering and successfully completing the JCDI program and following, obviously, all of the rules and conditions. You'll have an auto ignition interlock device on your vehicle. Do you already have that? You're going to keep that at least for some amount of time. And if he has the interlock, you can make a notation. I don't need interlock and scram and portable, whatever they feel like is best through JCDI. Once that gets going, I'm fine with. I am going to order that you serve the 10 days upfront time. That is going to be on the date starting, I'm going to attach, I'll give you this copy as well, but so like where it says 9 nights, you work that night
Yes, ma'am.
of the 9th.
Just like I'm on
So-
right now, too.
So you'll start on October 10th. I want you to turn yourself in October 10th at 6 p.m. And then you'll spend the 10th and the 11th, and they'll release you on the 12th. Okay?
Yes, ma'am.
And then, when you work days, what time do you get off?
4 o'clock.
4 o'clock p.m.?
Well, it depends on my relief, so it could be 4 to 4:30 to 5.
Okay, so the next time is going to be, since you're working days on the 16th, you're going to go at 6 p.m. on the 16th. And then you'll spend that night, the 17th, and get out on the 19th. If you don't have something written, days or nights, does that mean you're off?
We're so short-handed, it's a possibility, or I had to work overtime because I gave up 2 days overtime already for the 11th and 17th.
Okay. If it doesn't say days or nights on this calendar, does it mean you're off?
Yes, ma'am.
Okay. So that second one in October, you're going to go, we're going to get this done. Because that's your long days off. So we're going to get that week all done. So you're going to go in on the 16th, and you're going to get out on the 23rd. So that gives you 1 overnight, 16th, 17th, 18th. That gives you 7 days. And then that first one only gives you 2 days, so that's 9.
So you're saying go in on the 16th when I get off work that day?
Mm-hmm.
Okay.
We're just missing 1 day.
There's some in November on the back of it there.
No, we're getting this will be done in December. So you're gonna then go in on the 28th
Yes, ma'am.
at 6 p.m. and you'll get out the next day and I'll take care of that last day. So, and then Anna will probably need that too. Make sure you get all of those done. Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. You need to have a seat here in the courtroom and wait for probation to call you up. She'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Yeah. What was it?
This session covered 3 separate court matters. Patrick Gallagher pleaded guilty to his 3rd DWI offense, having reoffended just 4 days after his previous probation period expired. The judge expressed serious concern over this quick relapse, especially after a positive drug test for delta-8 THC, and declined to follow the original plea agreement's probation length, instead sentencing him to 10 years, suspended for 7 years of probation, with mandatory enrollment in an intensive outpatient treatment program, an ignition interlock device, and 10 days of jail time to be served around his work schedule. David Alexander Boyd, charged with deadly conduct for discharging a firearm, rejected a plea offer of 10 years probation with a $2,500 fine, and elected instead to take his case to trial, with the judge confirming he understood the offer would not be available again unless new circumstances arose. Finally, Larry Fletcher faced a motion to revoke his probation alongside 2 new and more serious charges, manslaughter and aggravated assault with a deadly weapon. After discussion between the prosecution and defense about how best to sequence the proceedings, the judge decided to reset the revocation hearing for sentencing in roughly 60 days, allowing time for the new cases to be properly prepared while avoiding duplicative hearings. Across all 3 cases, the court balanced accountability with practical scheduling concerns, reinforcing that decisions made in the courtroom carry lasting consequences for everyone involved.